Hello, my name is Darren Murdoch. I'm the President of the Scottish Law Agents Society. I'm currently a solicitor in practice, and I very much welcome you to this Scottish Law Agents Society CPD presentation on the Legal Services Scotland Bill, hereinafter simply referred to as the Bill. Now, this presentation is part of a wider presentation by my fellow SLAS Council members. I will deliver the first part of the presentation, and my fellow SLAS Council members Ian McPherson, Ken Swinton and Andrew Stevenson will deliver the remaining parts of the presentation. At the very outset, I would like to make it abundantly clear there are certain sections of the bill which I find utterly draconian, and these particular sections should have no place whatsoever in a civilised democratic society. I shall expand upon this particular point within my section of the presentation. However, I simply wish to lay my cards on the table at the very outset of the presentation. The bill is akin to a mighty river that sweeps all before it, with some of the sources from a variety of statutes such as the Legal Profession and Legal Aid Scotland Act 2007, the Legal Services Scotland Act 2010, or even so far as the much maligned Robertson Review, together with a general dissatisfaction in terms of the current regulatory system. There are perhaps times where we've all just found ourselves in despair at the current system. And I would also describe the current system as simply not fit for purpose. And like any great river, there is a propensity for a degree of pollutants to enter the bill. And I believe that this has occurred in this particular instance. It would be fair comment to say there is a high degree of apathy within the profession. This is typified by the responses to the recent Robertson Review, whereby in most instances there were less than 200 respondents to the various questions raised within the review. There is circa 11,000 solicitors in Scotland, and given that a number of respondents to the Robertson Review would not have been practicing solicitors, the percentage of the profession that responded to the Robertson Review is less than 2% of the overall profession, hardly a litmus test of the profession. Therefore, this raises a question as to why there is such apathy within our profession. I was recently on holiday for a period of 4 days, and I came back to in excess of 300 emails. Apathy within the profession is perfectly understandable. I get it. We are simply too busy with the day job to engage with the likes of the Robertson Review or any other review for that matter. We do not get paid for engaging, and even if we were to be paid, as expressed by many of my peers, there is that feeling at the very pit of our stomachs that there is no point in engaging with the regulatory reviews, for nothing ever changes for the better. Why should this bill be any different? The reason we should not be apathetic to the bill in hand is that it will set the regulatory playing field for the foreseeable future. Now, that aside, the bill comes with a hazardous to health warning. We have all benefited from residing within a Western liberal democracy, and during our lifetimes, the separation of powers has always been respected, and this is between the legislature, the executive and the judiciary. The separation of powers is the bedrock of any decent democracy. When the legislature has control of the judiciary, this leads to a loss of the balances and checks that the separation of powers provides. We need only examine 1930s Germany to observe the collapse in society when the rule of law in terms of the separation of powers is extinguished. Unfortunately, there are some more recent examples of the detriment to society when separation of powers is lost. And the examples that spring to mind are, Russia, Belarus, North Korea, etc., to name but a few. If the separation of powers is abolished within the bill, then we join the ranks of these countries. As our national bard would say, if we could see ourselves as others see us, it would from many a blunder free us, and foolish notion. Very profound words, given the draconian content of the bill. How indeed would we be perceived by the international community if we allow this bill to go through and it has a detrimental effect on the separation of powers? What indeed a foolish notion. The plans within the bill will have implications for the profession, the judiciary, and society as a whole. That is the very reason why this particular bill matters, and we should set aside our default apathetic position. The International Bar Association's 2016 report on the independence of the legal profession notes that a strong democratic society that observes and upholds the rule of law cannot survive by relying solely on the good faith of those who govern its political institutions. The effective protection of society from potential threats emanating from the abuse of power and the circumvention of basic democratic principles rests on, inter alia, the existence of a system of checks and balances. The independence of the judiciary and the legal profession is a fundamental pillar of this system. Significantly, the IBA mentions judges and lawyers in the same sentence and emphasises that both must retain freedom from interference by the state. Importantly, though, this independence is not to be equiparated with unaccountability, since independence is not provided for the benefit or protection of judges or lawyers as such, nor is it intended to shield them from being accountable in the performance of their professional duties and to the general law. Instead, its purpose is the protection of the people, affording them an independent legal profession as the bulwark of a free and democratic society. These observations should be of universal application. Compared to surveillance states such as Communist Hong Kong, Scotland is relatively enlightened. And yet, it is not enough that we have to rely on the benevolence of the current Scottish Government or any future Scottish Government, insofar as the bill empowers the state to interfere in the regulation of legal professions. It should be opposed. The rule of law is far too valuable simply to rely on the goodwill of the government. Solicitors and advocates are officers of the court, admitted to practice by the Court of Session, not by the government. This makes perfect sense. Courts are politically neutral. They do not have an agenda of seeking to impose policies, quotas, or performance targets on anyone or requiring solicitors to monitor or collect data about their clients' private financial and personal details. They are not subject to a political agenda. The bill would jeopardise the independence of the legal profession and inflict more bureaucracy on lawyers direct and indirectly. This will inevitably increase costs to the profession, only to be passed to our clients. I shall now turn to the individual sections of the bill, and I shall cover those sections which have an impact upon the separation of powers and interference by the Scottish Government. First of all, Section 3 governs existing regulators, such as the Law Society of Scotland, and this particular section sets out regulatory objectives. For example, a consumer should be treated fairly at all times. Somewhat of a subjective statement. Section 4 patronisingly sets out professional principles such as that a person providing legal services should maintain good standards of work. It's somewhat stating the obvious in this particular instance. Let's look at Section 5 of the bill. Now, this particular section allows Scottish ministers by regulation to add, amend, or even go so far as to remove a regulatory objective or professional principle. Now, the government has to consult with the Lord President, which does somewhat suggest that the drafters of this bill may have had somewhat of an inkling that the executive is coming very close indeed to encroaching into the territory of the judiciary. In fact, the bill repeatedly seeks to draw the Lord President into administrative collaboration with the Scottish ministers, potentially blurring the separation of powers and the respective roles and spheres of the executive and the judiciary, thus jeopardising a fundamental pillar of society within a democracy. Now, it would be interesting if the Lord President were to find himself disagreeable to the Scottish Government and the outcome of any such disagreement. No doubt about it, this is undermining a fundamental pillar of democracy. Now let's take a look at the extent of Scottish ministers' powers further, and in particular Section 20 of the bill, which examines measures which are open to Scottish ministers. This provides for directions and other measures to be imposed by Scottish ministers upon regulators, including the Law Society of Scotland. We fundamentally oppose this and any measure of direct state control over the profession. Section 20 provides for measures open to the Scottish ministers, empowering them to set performance targets and directing action and imposing penalties. Sections 89 and 90 amount to carte blanche legislation, allowing politicians to make any incidental, supplementary, consequential, transitional, transitory or saving provision. The bill would facilitate a further administrative burden upon businesses, but it's enabling the government to infringe the independence of the legal professions should be a source of concern for everyone in Scotland. This is a bill that will affect the whole of society, and anyone that values the checks and balances, protecting us against the overzealous use of power and control of or by the executive should be concerned in relation to this bill. The first question is, why indeed is this bill or these sections of the bill necessary? The Scottish Government generally refers with apparent approval to an evidence-based approach. Now, I would ask, where is the evidence of a need for Section 20? As we understand it, it was not requested either by the Law Society of Scotland nor the Scottish Legal Complaints Commission, nor was it requested by the profession as a whole. So this has come out of absolutely nowhere. If the Scottish ministers disapprove of something done by the Law Society of Scotland, they are quite able to show their displeasure without this particular provision and enter into a dialogue about it. Now, it appears there's somewhat of a checking provision so far as there is a provision that these measures, except the financial penalty, do not have effect without the written consent of the Lord President, Scotland's most senior judge. Some may say that this neuters the powers within Section 20. However, I would argue that it puts far too much pressure on the Lord President to be involved in day-to-day operations of the Law Society of Scotland, and is likely to be time and trouble intensive to not only the Law Society of Scotland, but also the Lord President, for no apparent actual benefit. There is no reason why the financial penalty does not require Lord President consent. What is wrong with a straightforward, direct dialogue instead of heavy-handed and overly legal process and procedure that is not necessary? I can't envisage any other profession whatsoever that is subject to such a form of state control. Why, therefore, is the legal profession being singled out and targeted in this prejudicial way? There seems to be prejudice on the part of the legislature against the legal profession. Would Scottish ministers propose to subject the regulators of accountants, doctors, nurses, surveyors in this way? I think not. Will they add Scottish Legal Complaints Commission to the list not as a regulator, but as a legal body with power over the profession? If not, then why not? We have a concern that Scottish Government would use their powers to impose upon the legal profession. This is of great concern, and if it comes to be, then the last person to leave the democratic building, please turn the lights off. The final section which I shall examine is that of section 49, which enables the Scottish ministers to intervene. I would argue that this is possibly the most outrageous extension of power by a legislature over a legal profession. This, I would argue, is truly Orwellian in nature. The Scottish ministers may, by regulations, make provision establishing a body with a view to it becoming a Category 1 regulator and specifying circumstances under which Scottish ministers may directly authorise and regulate legal businesses. Why is this thought necessary in a democratic state? This is off the scale. What on earth has led the Scottish Government concluding that there would be a need of a last resort provision? Again, where is the evidence-based approach? No regulations are to be made under this section without the agreement of the Lord President. And unless Scottish ministers believe that their intervention is necessary as a last resort in order to ensure that the profession of legal services by legal businesses is regulated effectively. However, requiring the consent of the Lord President may ensure this provision is never implemented, but this intervention is wrong in principle. What examples can the Scottish Government give of when this would be necessary, and when have the Law Society of Scotland ever given them this cause in the past? So let's wind up this particular section of the presentation. How far indeed have we fallen in just over a decade? Now, let me take you back to the Legal Services Act of 2010. If you turn to section 1A of that particular act, you'll see that the purpose of that particular act is to support the constitutional rule of law. You could argue that that particular section should be in the mindset of every legal draftsperson and should be a feature of every single act passed by the Scottish Parliament. Whereas, in terms of this particular bill, it would be perhaps more apt to narrate within section 1A of the bill, the purpose is to diminish the constitutional rule of law. Now, I mentioned at the outset of this presentation the apathy within the profession. I sympathise and I can understand the level of apathy. This is a bill that, if it is passed in its present form, will set the playing field for the rest of most of our careers, perhaps. It will be a bill that will affect ourselves, our businesses, society, our children, our grandchildren, etc. The separation of powers and the rule of law should be preciously guarded and not set aside by this bill. So therefore, do you remain apathetic? Thank you very much for listening to this presentation.